Namaste. Telugu Prajala Mana Sakshi TV. I am Swarna. Welcome to Sakshi TV special immigration show with attorney Prashanthi Reddy from the Law Office of Prashanthi Reddy PLLC. Please note that Sakshi TV now has 3 immigration shows every week on Tuesday at 3 p.m. EST with attorney Ms. Sheila Murthy, Wednesday at 5:30 p.m. EST with Ms. Attorney Ms. Prashanthi Reddy, and on Friday at 6 p.m. EST with Banu Ilindu. Please tune in to ask your questions. If you have any queries regarding immigration, please feel free to call us. Our attorneys would like to answer your questions. If you are an immigration attorney and would like to join us in our special shows, please email us at usc@sakshi.com or call us at 866-725-7441. Before we begin the show, please note down the information provided in this show is not a legal advice. It's for general information purposes only. Sakshi TV or its agents are not responsible for the use of this information. If you need a specific legal advice, please contact attorney directly. Today, we are going to talk about how to handle H1b Rfes. For that, we have our attorney Prashanthi Reddy with us. Without any further delay, let's start our show by welcoming her. Hi, Ms. Prashanthi Reddy. How are you? Welcome to the show.
I'm good, Swarna. How are you?
I'm good, thank you. So, can you please provide information on your law offices, practice areas, and your experience, please?
Yes, I practice immigration law, and we are located in New York City. And I have 20 plus years of experience doing immigration law.
Awesome. So, viewers, if you have any questions and would like to reach out Ms. Reddy directly, you can call her at 212-354-1010. Extension is 107. Or you can email her at prashanthi@reddyspu.com. So, Ms. Reddy, H1b Rfes, what to expect this season when it comes to specialty occupations?
So yes, they're very. So in this segment, basically, I thought we will go over H1 Rfes. Now, lot of you who know about H1s know that the H1 quota second round. Some applications got picked. So the first round is already over. All the cases were filed as of June 30th. And then the second round, they did another lottery and some other cases got picked. And those cases are due to be filed within 90 days. So by November, those cases, October ending, those cases have to be filed. So now what we're seeing in the H1s is the next step is, I mean, of course, cases are getting approved. A lot of cases are getting approved, but we're also seeing, as expected, some Rfes. So if you are an individual and you have filed your H1, not that you should get a request for further evidence, but if you do, then at least you will know what to expect by watching this show. And if you're an employer, you will know how to answer those common Rfes that you get from USCIS. So we will deal with the most common ones. And we'll go over them one by one. So the first one, as Swarna said, was
we have a caller. Yes. Before we talk more further about it, we have Mr. Rajesh from Virginia. Hi, Mr. Rajesh.
Hi. My name is Rfes. I would like to explain my situation, ma'am.
Yes.
I'm on CPT status. My H1 got picked up in the first lottery. My petition was submitted, and I'm working for one of the third-party vendor. So the situation is like my project is going to end by September 30. So I'm requesting my employer to apply premium so that what if my petition is get approved before 30th? Can I do H1B extension, or really if I lose my job, will that H1B petition kicks off after October 1st? That will be transferable, or how it really works? Like, I mean, like if I don't have any pay stubs on if my H1B got approved, that will be like okay, or I have to be again go on like next year lottery process.
So I didn't quite understand your question, but I'm going to try and answer it, and you can tell me whether if I understood it correctly or not. So you're concerned about your H1 getting approved before October 1st?
Actually, my question was, my contract is there for September 30. If my H1B is got approved before October 30, on October 1st I have to do for extension if I lose my job before September 30.
Yeah, so if you lose your job before September, well, first thing is you have to start working on a H1 from October 1st, not from before that. No matter when your H1 is approved, it doesn't matter. You continue in your present status until October 1st, or if if your H1 gets approved later, whichever comes first, October 1st or the date of approval of your H1. So now let's presume that as of the date of approval of your H1 or October 1st, whatever it is, from that date, you don't have a job, right? So my suggestion would be then to get onto the payroll. I'm presuming that whoever filed is it a consulting company? Is it a full-time employment? Who has filed your H1? Who has filed your H1? Is it a consulting company?
Consulting company.
Okay, so then get onto the payroll of that consulting company, and as long as your H1 gets approved, and if there is an RFE, it will be challenging because they might ask for contracts and proof that that the consulting company actually has worked for you. They can provide that proof by transferring you to a different client as long as that client is within the same MSA, or to put it in simple language, within the same county of where the previous client was located. So the LCA will have a certain work location, so we cannot change that. So as long as you're working within that work location and you show that as of filing the H1, the job was there, after that the job got over unexpectedly, then we can always continue the H1 by showing a different project as long as it's within the same MSA. Now, if you don't get an RFE and the H1 gets approved, hopefully, then you have to get onto the payroll of the company, whether you have a end client or not, and they have to quickly look for a job for you, and within the same MSA if possible, right? Then you don't have to file an amendment. But if it is not within the same MSA, then you'll have to file an amendment, and then they might ask, okay, when you started working on October 1st, what was the job? Where were you working? Show proof that you maintained your status. They could ask that question, and then you have to respond accordingly. So it depends really on, it's still a workable situation, but really depends on what happens, when your case gets approved, and whether there's an RFE or not.
Okay, thank you. Thank you so much, ma'am.
You're welcome.
Awesome. Thank you, Rajesh, for calling. So, Ms. Reddy, we can continue on our specialty occupations.
So, as I was saying, there are various reasons for getting a H1b Rfe. And I think one of the most common reasons is this specialty occupation reason. So, the very basis for getting a H1 is not everyone can get a H1. Only certain occupations qualify. And what are those occupations? Those occupations are those which require a bachelor's degree in a specific field. So, for example, a person who is a construction worker does not require by industry standards, right? General industry standards. What do other companies require? What does the industry require? What does the market require? So, by basic industry standards, a construction worker will not require a bachelor's degree. Therefore, the person doesn't qualify for a H1B. Now, that is a very extreme example. I just gave that example so that it will be easier for you to understand who qualifies and who doesn't. Some of the people that qualify that are again very clearly qualify are doctors, lawyers, accountants, professionals that clearly require a bachelor's degree. But what happens is sometimes it is not clear. There are some job occupations where it's not clear what the industry standard is, either because there's not enough documentation on it. So usually the USCIS will follow a book that's published by the Department of Labor every year, which is called the Occupational Outlook Handbook. So they like to follow that book, in which all these occupations are mentioned, and the minimum educational requirement for those occupations is mentioned. And there are some other details mentioned as well. So, but unfortunately, that book doesn't have all the jobs. It's not possible, right, to have, especially with new jobs coming up, new technologies coming up. Sometimes it becomes outdated. So they don't always have all the jobs. So when they don't have all the jobs, when it's a job which is not in there, then we have to prove. It becomes a little bit more difficult to prove because then we have to prove using other means that the job requires a bachelor's degree in a specific field.
Miss Reddy, does that book
Yes.
has the rules which will change every year when they publish it?
No, so it has updated information every year. The Occupational Outlook Handbook. It's OOH.gov, I think, or just type in Occupational Outlook Handbook on Google. So if it's not in that handbook, then it's possible that you have to look at other sources. Then you look at Google, right? You look at Dice, look at Indeed, look at all these job search websites to see for these particular positions what are employers requiring in the industry. So we have to compile all that and then provide them with a response when we get an RFE such as that. In some other cases, the Occupational Outlook will say, most jobs require a bachelor's degree, but all do not. Some do not. Some require an associate's, some jobs. So, of course, USCIS will catch hold of that and say, oh, but it says some does not. Some do not require. So, as per general immigration rules, you have to show that most often than not, a bachelor's degree is required. You don't have to show every single employer requires a bachelor's degree. You just have to show in general, a majority of them require a bachelor's degree. So that is still fine, but USCIS will sometimes fight us on that and say, that all don't require a bachelor's degree. Therefore, we cannot approve this case. So then we have to tell them what the law is when that situation occurs. So there are many other situations like that. In some instances, the Occupational Outlook Handbook will say a bachelor's degree in engineering is required, but they will not, or they'll say bachelor's degree in an MBA is required, or BBA, business administration is required. Then USCIS will come back and say that it's not a specific degree requirement, because not only should there be a requirement of a bachelor's degree, there should be a requirement of a specific degree, which means positions like, say, software engineer, they require a specific degree of computer science or a closely related degree like information systems, etc. A lawyer would require a specific law degree, right? You can't have just a bachelor's degree in arts. So sometimes when it's not even though the job requires a bachelor's degree, but it's not a specific requirement, and it's a broad, just a degree requirement. Sometimes they don't even say degree in what, they'll just say bachelor's degree required. In those instances, most probably it won't qualify for a specialty occupation. So you have to make sure before you file the case that you do all that research and do the due diligence and make sure that your occupation qualifies for a specialty occupation. So sometimes the job title of the occupation, every company has its own job title, right? But the duties will be the same, but the job titles might vary. Job titles sometimes are internal job titles. So you have to do that due diligence before you file the H1 and find out from the employer not just what the job title is, but what are the duties. And do those duties match with anything that already exists in the Department of Labor website or in USCIS, databases. And maybe then suggest an alternative job title to the employer so that it'll be easier for USCIS to identify what the job is. So that's another thing that we do. There's a lot that goes into filing a H1, and all this has to be done obviously before we file rather than at the RFE stage, right? So also, I think another thing to remember is sometimes the beneficiary may not have a degree. So sometimes you have to prove that. It's not only that the position should require a bachelor's degree, but you also have to show that the beneficiary has that specific degree. And sometimes when, as I said, there is no Occupational Outlook Handbook information, or there's not enough information, or there's an RFE that asks you to, show it's not just one requirement, right? So you want to show it in as many ways as possible that it's a specialty occupation. So if you can show it not only via the Occupational Outlook Handbook, or sometimes if there's not enough information there, you have to find alternative ways of showing that it's a specialty occupation. And that you can do by looking at the actual job duties. So even if the industry doesn't require a bachelor's degree in a particular field, but your duties, your employee's duties are so complex that they cannot be done without the person having a bachelor's degree in computer science, say. So if that is your argument, then you need to show the complexity of the degrees. You have to show why the degree requires a bachelor's degree, which part of it requires a bachelor's degree, why is it complex. You have to explain the degree, give examples. So that's another way of showing specialty occupation other than industry standards. Now another
Reddy,
way of,
sorry
yes.
to interrupt. We have a caller, Lavanya from Atlanta.
Okay.
Hi, Lavanya.
Hey, Swarna, how are you?
Good, how are you?
Yeah, good. Hi, Prashanthi garu. How are you, Andy?
Hello, Lavanya.
Hello, Andy. So I have a quick question regarding my H4. So I have applied my H4 almost like 3.5 months back, and still haven't received anything from any update on it. And I know the rules have changed after May 11th, right? So how do you think? I mean, how much time it will take more with the current process now? And also, I've expedited my case with the help of a senator in the local place that I'm living here, but I still didn't hear back from any of them. So can you help me with any of the suggestions, please?
Yeah, unfortunately, Lavanya, still the H4s are taking a long time. I know cases that are pending 6+ months. So there's still very high processing time for H4s, and I have no idea why. In general, yes, processing time even for citizenship cases, which used to take 6+ months, that has increased, almost doubled. Family-based green card cases doubled. So everything has increased, but H4 has been hit really hard, and it looks like you've done everything that you need to. And if it's beyond the processing time, in addition, I'm sure you already know, but you can open a service request and you can contact the Ombudsman's office. And also, I'm sure you know that if everything else fails, you have to file a case in federal court. But I wouldn't do that until it's, at least more than 6 months to 8 months pending. I wouldn't do it so soon. But it looks like you've at least taken that important step and, contacted your congressman.
Yeah, so here I want to understand one thing because, I have kept a client letter which says that, my client really needs me at my location. So I kept a reason, I submitted a client letter as well. So what other reasons would definitely help to expedite the cases apart from the financial loss? Yes, and job, job loss and my client is also giving the letter and everything, right? So what other reasons would USCIS would expedite the cases? What
so
other
as you
cases?
know, they have given a whole list of reasons, right, on the basis of which to expedite. And I can send you that offline. But basically, they have also said that simply financial reasons cannot be a reason for applying for granting of expedited status. It should be something more than just financial loss. They have said that somewhere in the memo itself. So I think job loss, in addition to financial loss, is a reason. But as you know, again, Lavanya, that most people are encountering this problem. Most people who have H4 EADs will lose their jobs if they don't have an EAD. And most people will have financial loss. Those two are obvious effects of what is happening. So everybody will have that. Right? So in addition to that, if there is another humanitarian ground which you can give, some medical issue, humanitarian issue, child support issue, or that you need to travel, due to some medical emergency at home. Obviously, you can't travel if you don't have status, then how can you come back, right? So these are some of the additional grounds for expediting, your petition, and they've laid them out very nicely. But I don't think it's
Okay.
helpful because most people have the same reason: job loss and financial loss.
Yeah. So does my client letter help me? Because, my client's reputation will go if, it will get jeopardized if I'm not, at the work
So
location
more
for a long
importantly
time.
is what you are doing for your client. Well, who is your client? Is it a healthcare
Okay.
organization? Is it a hospital? Is it an educational institution? Is it a non-profit research organization? That is another reason
Okay.
to expedite. That there is going to be some harm to the US economy or US healthcare if your H4 if you lose your job, if you're not able to do your job. So that is another reason for expediting. So it's not just putting a client letter, but if it's just a private loss that your company is facing, a business loss, they don't care
Okay.
about that. Because that's, as I said, that's common for everyone. And of course, you have to
Okay.
put the client letter because that's proof that you have a job and you're losing it. So that's a basic requirement. But also it depends on what you're doing. Who is benefiting from your work? That's something you can show if possible.
Okay. Yep. Thanks, Sandy. I hope I've got the information that I needed. Thank you so much. You're rocking, so
You're
please do
welcome.
that. You're helping a community there a lot, so thank you so much for doing it.
You're welcome, Lavanya. Thanks for calling.
Thank you, Lavanya. Okay. So, Ms. Reddy, is there anything more would you like to share with us about the specialty occupations?
Yeah. Right. So as I was saying that it's important to show that the beneficiary also has the degree that's required by the Labor Department or by the industry for the job. So if, for example, the person has a bachelor's in electronics engineering and the position requires a bachelor's in computer science, the industry standards is that, the degree requirement is usually computer science. Then you have to show the link between how the electronics engineering degree is related to, the computer science, how it's related to computer science, because computer science is the actual requirement. So I guess what you would have to do is then prepare a table of the duties that are being performed and how each course in your degree allows you to perform those duties. Or you can list all the courses in your engineering degree that are related to computer science and count the number of credits and see if that's enough to at least give you, an undergrad degree in, a related field like computer science. Especially electronics engineering and other closely related computer science degrees have a lot of computer science courses in them. So those courses might be sufficient to at least give you an undergrad degree in computer science. So it's possible to do that. Another way of doing it is also get an expert opinion letter in order to prove both the qualification of the beneficiary as well as the fact that the job is a specialty occupation. You get a letter from a professor in computer science saying that without a doubt, the software engineer position requires a bachelor's degree in computer science, and then the professor will give an explanation as to why he thinks that he or she thinks that is so, and of course then the evaluator's credentials are attached to that, their resume, to show how they are qualified to give that particular expert opinion. So these are the different ways, I think, in which that specialty occupation RFE can be handled.
Awesome. So, what about the availability of work in this situation?
Right. So another reason why one could get an RFE is the USCIS, issues RFEs to petitioning employers that failed to establish that the H1b beneficiary is working at a third-party site and would be engaged in specific non-speculative work assignments in a specialty occupation for that requested period of time, right? So Oftentimes, when people file H1s, they file skeleton petitions. They don't bother to put information that is required. We in our firm don't like doing that. We like to file a complete petition. And we usually put in, especially if it's a consulting company, and these situations usually occur in consulting company type scenarios where the person is working at a third party site, not if they're working, directly for the company. But in 80% of the H1 cases filed to USCIS, this is the situation. They're working at third party sites. So USCIS wants to make sure that that company who's filing their H1 actually has a need for the beneficiary. So the need cannot be speculative. It has to be non-speculative, which means that the consulting company cannot say that we don't have a job right now, but once they get the H1 gets approved, then we'll start marketing the person and get a job. That is speculative, meaning that you're hiring the person hoping to find a job for them, and that's not possible. You have to show that as of the date of filing itself, you have a job. So non-speculative employment is not possible. So when we are filing a H1, as I said, we always put in documents related to contracts, purchase orders, letters from the end client showing that the job is actually available. And also it's important to show that it's available for, you don't have to show that it's available for the entire duration of the H1. That used to be the case, but that law has changed. So now at least show that it's available for a good period of time. And it's not like something that is very short term, like 3 months or 6 months, unless you're filing the H1 for 3 months or 6 months, right? Also, you have to show that whatever job is available that they're going to be working on at a third party site, that it is specialty occupation related work. So you might say whatever you want in your letter. The employer can say, yes, he does this, he does that, it's a software engineer, it's specialty occupation. But they want to hear from the actual person, actual place where he's working. So they want to hear from the end client as to what the job will be. So it's important, therefore, to include a letter from the end client, basically mentioning what the duties are. If it's a software engineering position, but the duties are taking care of computers, solving people's desktop problems, then obviously it's not a software engineer position. There's no designing and developing of software, right? Which is what a software engineer does. So if there's a disconnect there, obviously the case will be denied. So these are the things to look for when you're looking at availability of work site. Also, USCIS requires employers to prove that the beneficiary will be engaged in actual and ongoing work in a specialty occupation. So as I said, it cannot be anticipated or based on prospective clients. So employers can't send a bunch of contracts to the USCIS and say, oh, look, this is all the clients that we have. So we are very good at finding clients. So we will find a client for them, for this person once, you file the H1. That's not possible. So you have to prove, in case the person is going to be working at various clients, right? And there are various job opportunities available. If the company is not into just consulting, but they're actually into doing work for different companies, like it's project based, then you have to show a steady workflow exists. So you have to show all the different assignments that the beneficiary will work on. You have to show all various contracts, purchase orders to show that, for example, maybe the consulting company is developing a website, to just put it very simplistically, for, I don't know, a car manufacturing company. So if you're saying that the employee is going to be working on designing and developing that website or that portal, then you have to submit contracts between the car manufacturing company and the consulting company, showing that there's a steady stream of work that exists. So I think that to show that there is work is, I think, the second largest biggest issue. Sometimes it becomes the most biggest issue or reason to get an RFE, especially if the job title of specialty occupation is standard. So if you're using a job title that is safe, like software engineer or doctor, obviously you're not going to get a specialty occupation RFE, unlikely. But you're more likely to get one of these other RFEs, and the second highest rate of RFEs, or rather the first highest, is about this, what is the work, what's the type of work that you have for the person. So if you're not a consulting company, and if you are say a car manufacturing company, and you're filing as a software engineer for your for a person, then you have to still show that you have work. You can't just file it and say these are his duties, that's it. They're going to ask, why do you need a software engineer if you're a car manufacturing company? You would need a mechanical engineer, or you might need a marketing person or a salesperson. Why do you need a software engineer? So that's again goes to the question of availability of work. So at the time of filing itself, you have to show exactly what he's going to be doing, what is the project that the person will be working on, show proof that that project exists. For example, he's developing a portal for the manufacturing company. Show that the portal exists or is in the stage of production, or show a blueprint, show whatever you have to convince the USCIS that the job actually exists. So it's easier to show that maybe for a big company, but sometimes I see like software engineer positions, being filed by doctors' offices. I'm like, how is this case going to get approved? And sometimes they do, but it becomes more difficult when it's a small company and it's completely unrelated. It becomes difficult for USCIS to believe that a full-time requirement is there. I mean, you can show a part-time requirement for a software engineer. Yes, he's helping with developing a portal, but that is not full-time work if it's a small company. So these are all the nuances that one has to look into to tackle this availability of work scenario.
So, viewers, if you have any questions and would like to reach out Ms. Reddy directly, you can reach her out at 212-354-1010. Extension is 107, or you can email her at prashanthi@reddysq.com. So, Ms. Reddy, can you explain more about beneficiary qualifications?
Yeah, we touched upon beneficiary qualifications, but USCIS usually issues RFEs to employers that fail to establish that the beneficiary was qualified to perform services in a specialty occupation. So an employer also must prove that the beneficiary has the required credentials to work in the specialty occupation. So generally, an employer must show that the beneficiary holds at least a bachelor's degree in the specialty field, or at least in the alternative, the beneficiary has sufficient work experience or license to engage in that specialty occupation. So, for example, if the H1 beneficiary does not have a bachelor's degree in a specialty field, but say has many years of experience or maybe has an associate's degree, then an employer may consider getting a combination, an evaluation done with a combination of education and work experience. And then the evaluator will show that based on this many years of experience and these courses that the beneficiary has studied, the beneficiary has the equivalent of a bachelor's degree in computer science. USCIS also asks for employers to include statements explaining how unrelated degrees are related. So I think we discussed this briefly. So a specialty occupation is not only where you have to prove that a bachelor's degree is required for a certain position, but you also have to show that the beneficiary actually has that bachelor's degree in that particular field. So if the person has, if the job requires a bachelor's degree in, again, I'm taking the example of a software engineer in computer science, but the person has a bachelor's degree in, say, mathematics or physics or electronics, there are two ways of tackling this problem. Either you have to show that the degree is related, so you have to show that a bachelor's degree in electronics is also qualifies the person for the position, right? So that's a little difficult because industry standard is showing that it doesn't. So you have to disprove that industry standard of that OH that we talked about and show other proof that, many people or majority people, employers hire persons with electronics engineering for a software engineer. It's not always computer science. So you can disprove the requirement. That's one way of doing it. That's a hard way of doing it. Or second, you can show that physics degree or the math degree is related to the coursework. Meaning have a table, design, develop, software. So that design, develop, software, what is the course in the mathematics degree that is related to designing and developing of software? Is there some computational subjects that will help him design and develop the software? So that's how you have to create a table. The other way of doing it is combining the education and work experience. So if the person has a bachelor's degree in mathematics and say has 3 years of experience or more in some computer science field, has worked previously as a software engineer for 3 years, you can get a work experience evaluation done or an expert opinion letter, either one, showing that the combined effect of the bachelor's degree in math and the computer science experience gives him the equivalent of a bachelor's in, say, information systems. And that qualifies for, the computer science position, qualifies for the software engineer position, right? So that's definitely one way of doing it. In another instance, it could be that the person doesn't have a bachelor's degree. But, for example, if the person is in India, has finished a bachelor's, a BSc in computer science, that's only a 3-year degree. In the US, to be called a baccalaureate degree, you have to have 4 years. So a bachelor's degree in India may not be equivalent to a bachelor's degree in the US. So how do you deal with that then? So one way of dealing with it is adding the 3-year bachelor's degree with the work experience. So 3 years of work experience is equivalent to 1 year of college. You can equate 3 years equivalent to 1 year. That's how USCIS equates work experience. So if he has 3 years and he has a 3-year bachelor's degree, so that equals 4 years of college, right? And thereby, they qualify for a bachelor's in information systems or computer science or something closely related. So that's another way of really showing that the person actually qualifies.
Miss,
So
that
yes.
applies to all kind of qualifications? Like
yes, anything. It's not just computer science. I'm just giving the example of computer science because that's what a lot of viewers might understand, because a lot of them are in that field. But that can apply to anything. But we have a problem in some other fields. For example, it becomes a specialty occupation problem also. So for people who are going into the marketing field, right, and maybe want to join as a marketing manager or marketing research analyst, even though we know the person without a bachelor's degree minimum cannot do those jobs, USCIS is denying such cases because they're saying that the job requires a bachelor's degree in business administration and it is not specific. It's a general degree requirement, like saying engineering or arts. So it's not a specific degree requirement, therefore we're not going to approve it. As opposed to that, if the person was working as a financial analyst and the requirement was a business administration degree in finance, not general business administration degree, then that would qualify for a H1 because it's a specific major. Or human resources manager, HR specialist, BBA in HR or personnel management. Again, specific, so it's good. Non-specific, not good. So, any of these, whichever position you look at, you have to see whether the degree requirement is for a specific requirement or a general degree requirement. So any bachelor's, if it says, then obviously it doesn't qualify for a H1. So that's, a little bit about what the beneficiary's qualifications should be.
Okay, great. So, what to do for the maintenance of status?
There's another reason that we get Rfes is really maintenance of status. And there's a lot to say about maintenance of status, especially with reference to change of status. And these CAP cases, most of the CAP cases are change of status from F1 to H1. Majority of the cases are filed for F1 students. So change of status from F to H, in a lot of cases we get maintenance of status Rfes. And maintenance of status, so what they want to make sure is that they have maintained status in their F1 before they can actually approve the change of status to a H1. And an F1 maintenance of status usually means, number one, that they have gone to school and gotten the required credits, right? And they've never been, their CBIS records are current and they've never been out of status that way. They've done everything that they needed to do as per the DSO. Number two is if they are on OPT, that they have worked for the minimum required period as per the OPT regulations. Now, as per OPT, you can voluntarily, if it's so there are two types of OPT, preliminary OPT and then of course the STEM OPT. So STEM OPT has different requirements, the preliminary OPT has different requirements. STEM OPT requires you to work, actual work, not interning, without money. It has to be paid work. The preliminary OPT allows you to do internship, that is unpaid work. Again, certain number of hours are required in both. So all the requirements are very stringent. So the maintenance of status Rfes will dive deep into whether you maintained your OPT or not. And also whether you, as I said, you maintained your full-time student work status and you took the requisite number of courses or not. Or was there any lapse in your courses? Did you take a break, unauthorized break, and skipped some courses, or you failed some courses, etc., etc. But more important is people who are on CPT. As we all know, because students are not able to get their cases picked in the first round of the CAP sometimes, and sometimes not in the second, and sometimes not even in the third. They continue their education, take up one master's after the other, and they take up CPT so that they can continue working. CPT is curricular practical training, whereby you're doing your course and you are working at the same time. So CPT again has very stringent requirements, and oftentimes we see maintenance of status Rfes to see whether they maintain CPT requirement or not. So CPT requirement is that the university has to attest that the CPT was a necessary part of the course curriculum, so that it was an important part of the course curriculum, and without that practical training, the course would not be complete. It was necessary for them to learn about the course, to do some practical training in that course. So they have to attest to that it was a requirement. There's also some requirements with reference to signing a contract, requirements with reference to notification when there's a change in employers. So oftentimes they will, the RFE will say, prove that it was a necessary, integral, important part of the course. They'll say sometimes, show us how the duties that you perform during your CPT, during your job on CPT, is related to the courses that you're taking. Sometimes it's tricky. The person will be doing an MBA and he'll be working in the computer science field as a software engineer. So you have to show how it's related. Sometimes it may not be. And then for such people, then their case gets denied. There's also this thing about day one CPT. Most of you must have heard of that. Taking CPT on the first day of starting your course, and often frowned upon by USCIS, and that's why they send out these Rfes. But actually speaking, there is nothing wrong with day one CPT as long as you're able to prove that the CPT was required as an integral part of the course from day one. So there are degree programs which are exactly that in nature. They depend on work experience to give you the practical knowledge, and then they want the theory and the practical knowledge to happen at the same time. They're called executive programs. And usually they take place, in the evenings or on weekends. So these executive programs often have this kind of CPT, day one CPT requirement, where, that's one thing about CPT. You have to show that you met all these requirements. Oftentimes, the person who is taking part in the CPT is working in a different state and studying in a different state. And that prompts maintenance of status Rfes, because they are asking the student, how do you go to school and work in different states? How is that possible? So they ask to show that the courses were not online, that they actually physically attended school. So often we end up putting in air ticket proof that they flew every weekend to that particular state. So copies of air tickets, copies of hotel accommodation, copies of utility, food, whatever restaurant, whatever they spent, their credit card bills, parking, gas, whatever, if they have rented a car, to show that they were physically present at that institution, and it wasn't like an online thing. Because as there's more presumption of a fraud now after all the fraud that has happened with, universities doing online courses, not having courses at all, and saying that they have courses. So that has happened in a couple of instances. So they're being very careful to make sure they don't believe the universities anymore. Even if they say that it's a in-person class, they don't believe. They want to see physical presence. So that's some of the things with reference to maintenance of status. So other than the student issues, USCIS issues Rfes to petitioners that fail to establish that the H1b beneficiary had properly maintained his current status. So sometimes you're filing an extension. They want to make sure that the previous H1 that they were on with the same employer, that they met all the requirements, that they worked in a specialty occupation, that they were paid. Oftentimes, it's not unusual for employers not to pay. If they're not paying, then pretty much the employees are out of status. So they want to see pay stubs, they want to see W-2s, they want a job description to see what the job actually was. So sometimes they do that as well. They dive deep into their previous status to see whether they were in status or not, even in an extension situation. And sometimes it might be as simple as not having an I-94. So if you're not in valid status, you obviously cannot file for an extension of status or change of status. Sometimes there might be a gap because you forget that your I-94 is expired, and then you file the H1, and it's pending, and then you file another H1. So there are a lot of instances in which people are filing multiple cases, and it's confusing for USCIS as to what the status is and whether they have maintained status or not. These are called bridging petitions. And usually what happens is, for example, the person files a H1 extension, say. The H1 extension is pending. There is an RFE, but the RFE maybe is a difficult RFE to respond to. So the person actually files another H1 while this H1 is pending. So they have two H1s. So on the second H1, they get an RFE saying maintenance of status. Your I-94 is expired. You're filing one H1 based on the receipt of another H1. We can't see that you maintain status. So they're refusing to accept those bridge petitions. So that's another instance in which they're asking for maintenance of status. I-94 records, approval notices. They want the case to be approved, the case that is filed in between to be approved before they file the second case. They want the first case to be approved. So they're asking for approval notices, etc. Of course, if you're filing for a transfer of a H1, then they want to make sure that you have worked in the previous company, so they're looking for pay stubs or employer verification letters. If in some instances the employers don't pay, they're violating the Department of Labor regulations, and when the employees complain, the employees get into trouble because they're out of status. So USCIS has agreed in instances to accept other proof that they have worked, even if they don't have pay stubs, because the reason they don't have pay stubs is because the employer has refused to pay even though they have worked. So in some instances you can show other proof, especially if there is a complaint against your employer to DOL. So that's, I think, some of the issues with reference to maintenance of status.
Okay. So that's great, Ms. Reddy. So viewers, if you have any questions and would like to reach out Ms. Reddy directly, you can reach her out at 212-354-1010. Extension is 107, or you can email her at prashanthi@reddysq.com. So Ms. Reddy, what is availability of work in this situation in-house?
In-house, yeah. So we've talked about availability of work when you're working for a consulting company when you're working for a third-party client. But sometimes consulting companies will file H1s for saying that the person is not going to be working at the client side, but will be working in our office. And they will submit elaborate project documentations. They will submit product information to show that the beneficiary will be working on our own company product. Unfortunately, because of the fraud involved in doing this, like a lot of companies think that we can show non-speculative work by showing that they'll work in-house and then move them to a client once they come to the US or once they join us on our payroll. Then we can market them for off-site work, because we don't really have in-house work. We're just showing that those elaborate project documentation, we have created it, we are showing it just so that the H1 gets approved. So obviously that USCIS is aware of that, and they send Rfes in these instances asking for non-speculative work assignments for the same thing again. If you're going to show a project report, or you're going to show that you have a certain product and you're marketing that product to other clients, and you need this person to work on that product and he'll be working in your office, as I said, then you have to show contracts between yourself and that client that you have. If you're developing the website for that car manufacturer, you have to show the contract that you have between you and them, and you have to show what money was exchanged. So you have to have concrete proof. You can't just submit a project report and say, okay, this is a project report, the person will be working on those projects. Because, consulting companies have been known to submit dummy project reports. So be careful when you do in-house. This is not a stopgap and a way of getting people in and then sending them out. Because even if then USCIS catches on to that as well. So when you keep doing this, USCIS will say, oh, you've hired him for an in-house project, then you filed an amendment within a month, after a month, for an off-site project. Why did you do that if you have work in-house? That means it looks like you don't really have work in-house. You just produce this documentation in order to, get the initial approval of the H1. And then you moved him out. So, be careful when you use this in-house, unless you actually have work for them and they're going to be working for a certain period of time in your office. I would suggest not, using this as a tool for getting H1s and then moving people out as soon as they come to other projects.
Okay. So, what to expect about LCA correspondence to the petition?
So yeah, this is doesn't happen that often, but sometimes the LCA we file, the LCA will have different information from what the petition has. So that could cause an RFE as well. So sometimes when the LCA information is incorrect, say there's a clerical error and the work site is put wrong, or maybe the suite is wrong, the address is wrong, whatever it may be wrong, and then the actual address is something else. So that LCA then doesn't meet the conditions of properly filed LCA. And then the problem is that if you file the petition with the wrong LCA, you cannot again correct the LCA by filing a new LCA. You have to file a new petition, because you have to show that the LCA was approved before filing of the petition. You cannot file an LCA and try to correct it after filing of the petition upon receipt of the RFE. You can't do that. So you'll be just forced to file a new petition all over again. So it's important to put in all the right, correct information, whether the employer is exempt or not, H1b dependent or not. There are a lot of information required in the LCA, and everything has to be mentioned correctly. Otherwise, you'll be forced to file a new LCA, but also a new H1b petition. And also, the LCA, as I was saying, must properly correspond with the position being offered to the beneficiary. With reference to job title, the wage level, all these things have to correspond. So you can't put one wage in the LCA and put another wage in the I-129 petition, or submit an employment letter with a different wage. Everything has to correspond. So that's another, that's with reference to the LCA. Be careful how you file it. Make sure you file it, without any errors. And if you see there's an error, then correct it before filing your H1. Redo the LCA. LCA takes 5 to 7 business days. It's better to take that time and file a new LCA rather than, have to file a new petition 3 months later.
Awesome. So thank you so much, Prashanthi, for clarifying all the questions. Viewers, before we wind up, if you have any questions and would like to reach out Ms. Reddy directly, you can reach her out at 212-354-1010. Extension is 107. Or you can email her at prashanthi@reddysq.com. This is Swarna signing off. You're watching Telugu Prajalamana Sakshi TV. Namaste.